Hi, I'm Adam Friedman. Welcome to another edition of the Weekly Friedman, your source for the most relevant information on the default industry. Joining me today is Friedman Vartolo partner, Zach Gold. Zach is one of the preeminent foreclosure litigators in New York State and is a partner at the firm and runs our litigation practice. Zach, thanks for joining us today.
Thanks for having me.
So today we'll be discussing a New York foreclosure litigation trend regarding power of attorneys. So Zach, before we jump in, why don't you tell our audience why we're discussing this topic today?
Sure. So there was a Second Department decision called U.S. Bank v. Tesoriero from 2022. And in that decision, the appellate division held that the power of attorney provided by plaintiff's loan servicer was insufficient because it contained language limiting the authority of the loan servicer based on a unproduced related servicing agreement. And the defense bar and judges have been using this decision to defend and fight our foreclosure. And we've been getting a lot of decisions recently denying our motions on the basis of this decision.
All right, so Zach, when we're talking about power of attorneys in this context, we're always talking about a power of attorney giving a servicer the ability to speak on behalf of the bank or note holder. Mm-hmm. Is that correct?
That's correct, yeah.
Okay. So look, I don't litigate nearly as much as you do, right? But pretty much every motion is going to require a client affidavit from a servicer speaking on behalf of the loan holder, right?
Exactly.
And you're telling me the power of attorneys these loan servicers are relying upon may be rendered invalid. This sounds very problematic. What do we do?
Well, there are really two options that come to mind. The first one would be get an updated power of attorney that doesn't have this limiting language. The other option that comes to mind would be to provide the old power of attorney with the servicing agreement that's referenced in the power of attorney.
Okay, so the first option sounds easy, okay? Yeah. Not easy to do, but easy to understand. Mm-hmm. So we're saying the initial power of attorney is problematic, get a new one. Mm-hmm. In the second example, or the second solution, you're saying we can keep the old power of attorney, the one that was rendered invalid, mm-hmm. but include the loan servicing agreement. Right? How does that work?
Well, really, the court wants to see that there's no language in the servicing agreement that limits the authority of the loan servicer. So what you would do is presumably provide a redacted copy of the loan servicing agreement, remove any confidential or proprietary information, just to show that to the court that there's no language in that servicing agreement limiting the authority of the loan servicer.
Okay, and let's make sure we break this down, because sure. I think this is not the core issue, but probably the most confusing part of this topic. Mm-hmm. We're saying in the Second Department decision, mm-hmm. a power of attorney was determined to be invalid, mm-hmm. right? But the loan servicing agreement was not included.
That's correct.
So they're saying we don't know if the loan servicing agreement limited the servicer's ability to speak. It might have, it might not have, but correct. Since we haven't seen it, correct. And we don't know for sure, you're not able to speak on behalf of the bank.
That's exactly.
Okay, so to recap again, you're saying our two solutions: get a new power of attorney, mm-hmm. or provide the old power of attorney, but in this instance, provide the LSA and show that it's not limiting. Obviously, if the LSA does limit, mm-hmm. then we have a problem there too.
Correct.
Okay, so what are our key takeaways?
Our key takeaways are just to, acknowledge that this is an issue, and we've been getting a lot of decisions from the court denying on the basis of this decision, this appellate division decision. And two, another key takeaway would be that when you're preparing these power of attorneys, to just be mindful that the court will be scrutinizing them. So you would want to you probably want to avoid including language that limits the authority, as was the case in Tesoriero. And it's a very common standard POA that we see a lot. So when preparing future POAs, you want to make sure that you don't have this language.
It's interesting, right? It's such a simple topic.
Right.
Like you think power of attorney is so simple,
right.
so straightforward.
Right.
And you can kind of see how it can be used against you and become a different issue.
Yeah.
So listen, Zach, I really appreciate it. Thanks for your insight. For our audience, thanks for watching. Please comment below. If you have any ideas for future episodes, please let us know. We appreciate it. Have a good one.
Thanks for having me.